First, I just wanted to thank all of you for joining today's webinar on Unpacking GENDA. My name is Trevon Mayers. I'm the Director of Policy and Community Outreach here at the LGBT Center in New York City. For this webinar, we wanted to have a thoughtful and comprehensive discussion around the Gender Expression Non-Discrimination Act, or GENDA, and really take a closer look at the existing protections and policies that TGNC New Yorkers currently have under the law, and also provide additional considerations about how the proposed legislation impacts the community broadly. With particular focus on sort of the nuanced impact that it has on historically marginalized communities. I know that many of you, for you, this conversation is timely given the recent news about the Trump administration's effort to take away existing federal protections. So we'll talk a little bit more about that as well. For those of you who don't know, this webinar is part of our LGBTQ Power Speaker Series that we are offering really to engage partner organizations across the state. And the goal of these webinars is for LGBTQ and allied communities to hear about relevant advocacy opportunities and to get a broader understanding of what it takes to mobilize community and constituencies to advance LGBTQ affirming protection statewide. So in the barriers to, we had a presentation in May on the barriers to success and what it really takes to move policy forward. In New York, we also had another one. We had a presentation that Milo had on GENDA on October 10th. And again today, we have an upcoming presentation with the Hispanic Federation around engaging Latinx communities in civic organizing. That will be in November. And we have a presentation in December with Vocal New York around best practices to center a marginalized community in our advocacy work. The registration for these webinars is forthcoming, and we'll make sure that you have details to RSVP once they're available. Also, just wanted to point that as the Center's advocacy work continues to grow, it's really important for us to make sure that the more than 1 million LGBTQ members in New York are connected, informed, and engaged in the fight. So I would be forever grateful if all of you listening could take 2 seconds to just grab your cell phone and text the word RiseOut to the number 69866. By doing so, you'll join our RiseOut mobile network and automatically start receiving alerts on ways to take action for LGBTQ rights in New York whenever there's an opportunity to be heard and really make a difference. So that includes updates on voter registration deadlines, election dates, and other forms of civic engagement. If you are already signed up, you are encouraged to share the code with friends and make sure that they're also a part of the fight. Before we start today's webinar, I just want to go over some processes to keep in mind. Everyone may have noticed, but you have all been muted upon entry of the webinar so as not to distract the presenter and other participants while the webinar is taking place. We're also recording the webinar, so to make sure that we're moving forward, there will be a few pauses during the presentation where we will take written questions. If you think of a question, please use the chat function at the bottom of your screen to type it and share it with us. We hope to take a few questions from the chat throughout the presentation and again at the end. So with all of that context out of the way, I'd like to introduce our presenter, Milo Primo. Milo is a queer transgender person. Preferred pronouns are he, him, and his. A civil rights attorney, professional consultant, seasoned public speaker, and the founder and CEO of Just Roots Consulting, LLC. For more than 15 years, Milo has fiercely advocated for the rights of LGBTQ communities across the country, from grassroots organizing to overhauling corporate personnel policies to spearheading high-level statewide policy reforms. So without further ado, here is Milo.
Great, thank you so much. And can everybody hear me? Can you hear me, Trevon?
I can hear you, yep.
Good, wonderful. Well, thank you everybody for coming and spending some time with us this afternoon. There is a lot of information that we're going to cover. in a fairly short period of time. So I hope you'll all stick with me and you're not too sleepy after lunch and you have your afternoon coffee or tea in hand and are ready to go. It's always a little challenging with webinars because I can't actively see how you are reacting to the material. So we do encourage you to ask questions along the way. Trevon will keep an eye on those and we'll make sure to pause for questions throughout to try to respond to that as we go. But hopefully I make the information as clear as possible and it won't be too onerous for you. So let's jump in. Let's talk about what it is that we're actually hoping to achieve today when we're saying unpacking GENDA. The first thing is we want to learn what GENDA actually is, what it will literally do and symbolically do, what its possible impacts really are. And then we want to take a step back and actually think about the assumptions that are underlying the continued push for GENDA. As we'll talk about, it's a piece of legislation that we've been working on as a community for a very long time. And I think it's helpful to periodically, with anything that we do in civil rights work and in movement work, to periodically take a step back and review what it is that we're doing and why we're doing it, and look at the assumptions that we're making around the work that we're doing, and to make sure that those assumptions are still accurate and serving the goals that they're meant to serve. So a lot of this presentation will be focusing on that. In so doing, we're going to review current federal and state protections against discrimination. And as Trevon mentioned, we will be talking about media and about the information that we receive from media sources about what is happening with our rights, the way that it's framed, and the way that it impacts our community and the work that we're doing, and also talk specifically about the memo that was leaked to the New York Times this past Sunday, so that we can assuage some fears around that. And then finally, we're going to engage some critical questions about why GENDA still matters. And I think that this is really the important part, is, you know, walking away from this conversation with more information about the historical context of the bill, about where we are as a movement, what rights we have and do not have, and then coming away with this with tools to have continued conversations, this being the beginning maybe of the conversation, but continued conversations about why this is important and how we can talk about it in a critical way. Okay, so let's jump in. So the first thing to note is that in 2002, LGBTQ advocates were pushing an inclusive legislative agenda that would have added sexual orientation and gender identity and expression to the human rights law, civil rights law, education law, and hate crimes law in New York. During legislative negotiations, in order to get sexual orientation to move through, advocates agreed at that time to drop gender identity and expression from the bill, with the intention and the promise to come back for it later. This might be something that you're familiar with, this sort of move to come back for something that isn't as convenient to work on right now at a later time. We'll talk in a minute about, or actually we'll talk right now about how that plays out in other places. You might recognize this tactic from the federal level as well, most notably NYT, the Federal Employment Non-Discrimination Act, is a bill that would have added federal employment protections based on sexual orientation and/or gender identity and gender expression as well. It's been introduced in all but one Congress since 1994 without success. The closest we got to securing NYT was in 2007, 5 years after we got SONDA in New York State. But even Democrats at the time on the federal level were worried about what it would mean to protect trans people in the workplaces, citing, of course, bathroom issues, because that's all that really matters to non-transgender people, is what happens to trans people in bathrooms. And so advocates dropped the trans element of the bill in hopes to get sexual orientation covered, promising to come back for trans people later, and it did not work. Despite that effort, NYT died in the Senate, has not moved forward since. So going back to New York, we see that this is a system that did work in New York, the strategy. And in fact, in 2002, sexual orientation through SONDA was passed and adopted in 2003. So sexual orientation is added to our law. It is an explicit protected status in those statutes that are listed there. So as a result of this, GENDA, which is the Gender Expression Non-Discrimination Act, is our state bill that is attempting to add gender identity and expression to those same statutes, to the human rights law, civil rights law, education law, and hate crimes law. It's been proposed in almost every legislative session since 2003 and has been approved by the Assembly many times, but always dies in a Senate committee. This problem has persisted not only because of the Republican-controlled Senate here in New York, but also because of a group of Democrats called the Independent Democratic Conference, also known as the IDC, which formed together as a block of votes that used their power as a sort of a swing vote and a voting block to actually side with Republican votes on a lot of issues. And so with those sort of situations combined, we have not seen GENDA move through the Senate committee onto Senate floor in all the years that it's been brought. Notably, the IDC formed in 2011 and it just dissolved this past spring. So that particular obstacle will no longer be there moving forward. Nevertheless, at the rate things are going, without a major sea change of a true Democratic majority in the state Senate, during this upcoming midterm election, we will likely not see GENDA pass in the near future if things continue the way they've been going. So all the more reason to get out and vote. I'm a huge advocate for voting. So if you haven't, I guess it might be too late to register, I'm not sure. But, if you haven't done so, please do so soon. The big lesson to learn here, the big takeaway from this is that half-baked legislation has far-reaching and long-term consequences for communities that are left out, and that you don't get that many bites at the same apple. So we saw this happen with SONDA coming back, advocates promising to come back for trans rights, and it has not worked out. And it happened also on the federal level with NDA and in many other circumstances as well, but these are good examples. So this is where we are. So let's talk about what GENDA would do. I think there's a lot of ideas of what GENDA, the power of GENDA and what it would do. So let's talk about first what it would literally do, and then we'll talk about what it would do symbolically. So literally, GENDA would add gender identity and gender expression to the list of protected statuses, which, depending on the statute that you're looking at, also includes a variety of other ones like race, creed, religion, color, national origin, sexual orientation, military status, sex, age, marital status, status as a domestic violence victim, disability, pregnancy-related conditions, predisposing genetic characteristics, prior arrest and conviction records, familial status, etc. So there are a number of other explicitly protected statuses that are spelled out in the law, and this would add gender identity and gender expression to them. Of course, people may experience discrimination based on more than any one of these protected statuses at the same time. For example, trans people often experience discrimination not only because of their actual or perceived gender identity or expression, but also because of their race or because of their actual or perceived sexual orientation or disability. And these laws serve to protect multiply marginalized people who have historically borne the brunt of the systemic and widespread discrimination in our society. So by adding explicit language to the statutes, it would give just a little bit more teeth for these communities who experience these issues. Importantly, the other piece of what it would do is to codify in the law, and what that means is to institutionalize it, to actually add language to the statute itself. Rights and protections that we already have through other means. We have these rights and protections through regulation at the moment, and also through a number of court decisions in New York State. So there's legal precedent, which means that there's a history of recognizing rights and protections for trans people and gender nonconforming people already in the state as a general public policy. And that would kind of reduce it down and put it into the language of the statute itself. So what would GENDA do symbolically? And this is different, and it's really important to think of the differences. So of course, the passage of GENDA could have an extraordinary symbolic impact separate and apart from what it would literally do. First, it would symbolize that the very powerful legal and political institutions in our state recognize the lived experiences of trans people and are willing to take action to protect them. And that is definitely no small feat. Not only that, but it would also symbolize that our state recognizes that trans lives are as vulnerable and important as people who experience discrimination based on their sexual orientation. We already know this in our hearts to be true, but seeing trans status on par with sexual orientation is a great equalizer that we've been waiting on for a decade and a half or more, really, if you, depending on who you talk to. So part of this is this feeling of unfairness that some folks in the LGBTQ community are recognized in the law and some folks aren't. And the idea that we would equalize that in the eyes of the law is something that is important symbolically. The passage itself would also inspire a large-scale news cycle that would bring more visibility to trans lives and would also put the public on notice that trans people are protected under state law. As an aside, we will talk more in a few minutes about the role of media regarding our rights, so stay tuned on that, but it is fair to say that that is also a symbolic win. And then finally, GENDA's passage could potentially send a message to all who might wish to harm trans people that there would be an increased criminal liability for doing so through the hate crimes component of the bill. More on that later too. So it's important to distinguish between GENDA, what it will literally do, and what we hope it will do symbolically. There's no guarantee that we will see these symbolic bullet points in reality, but as you'll see throughout our discussion, the promise of these symbolic points are central to serving to several of the assumptions underlying our continued push for GENDA. So let's look at those now. So as I said at the very outset, as a general matter, it's always a good idea to periodically reflect on and critically question the assumptions underlying the movement work we're doing on behalf of a very large and very diverse community. Movement work doesn't happen in a vacuum. The conditions of the world around us are constantly changing, and it necessitates that we be critical and flexible to meet the present day challenges, concerns, vulnerabilities, and needs of our community. So to that end, the point of this discussion and the point of looking at the assumptions is to consider and articulate what it is that we are hoping for and assuming that we would get out of GENDA, or the things that are pushing us to move it along, and try to unpack them one at a time. So first and foremost, we have, under current state federal law, transgender and gender nonconforming New Yorkers are not protected or have less protections than lesbian, gay, bisexual, queer, and other people. So that's one assumption, is that we are unequal under the law, under state and federal law, and we need GENDA in order to equalize us and to create some equity in the law. So that's the first assumption underlying the push for GENDA. The next one that we hear a lot from folks who have been doing this work for a long time is, hey, we've been fighting for so long to get GENDA, we can't give up now. And that's a really important one that I look forward to discussing with you in a few moments. And then the last two are related. One is hate crime laws are effective means of deterrence for possible offenders, which is to say that by having the hate crime provision and component of GENDA pass, it would actually serve our community for the better by actually deterring people from committing hate crimes based on our trans status. And then finally, it benefits the trans and gender nonconforming and larger LGBTQ communities to strengthen criminal laws. Whether or not we've actually ever said that one out loud before, it is an assumption that's implicit to the way that GENDA is currently formulated, and it's definitely something worth considering as well. So that being said, let's jump in and take a closer look at the first one. We'll start with that one because it's kind of the biggest one. And go from there. So the first assumption is that under current state and federal law, trans New Yorkers are not protected or have less protections than LGBTQ people. In this section, I'm going to walk us through what protections we actually have under current state and federal law, starting with a brief civics lesson. So I hope for those of you who slept through your civics classes in school, this will be interesting. And for those of you who already know this, I appreciate your patience as we walk through this. But so let's start. So when we think about the law, and I put that in quotes because it's sort of this big thing that we talk about, the law. We think of it often as statutes, which are those things that come from Congress on the federal level or state legislatures. However, the law comes in many shapes and sizes. So first and foremost, we have the US and state constitutions, which outline exactly what powers each branch of government has and what basic protections and rights are available to us, the people. This includes guarantees of equal protection under the law to guard against discrimination by the government itself. Everything in the Constitution is considered part of the law. The constitutions establish 3 branches of government, and we see those in the light blue: the legislative branch, the executive, and the judicial. So the legislative branch is our Congress on the federal level, and our state assembly and Senate on the New York state level. These are all people we elect to represent our needs in these capacities. Whether or not they do that is a different question that we won't get into today. But we elect them, and they create statutes. They create bills that become statutes that reflect and address those needs, allegedly. The legislature makes and passes bills, which are given to the head executive, who signs them into law. These statutes are all part of the law also. Some of these laws specifically authorize the creation of executive agencies, which are controlled by the executive branch and are tasked with putting the law into action and enforcing it against people who try to break it. So like moving over to the left, let's look at the executive branch. This branch is headed by elected officials as well. So these are people we elect, the governor or the president, who can make the law in 3 different ways. So they can sign legislative bills into law. They can issue executive orders, which are usually unilateral policy decisions or directives that are often time sensitive, and they don't have a lot of staying power. They're very easy to override by the next administration that comes in. And then finally, they can also appoint people to spearhead the executive agencies, which are tasked with implementing and enforcing the law. So let's talk about the agencies, because this is important for the rest of the conversation. We are all familiar with what these agencies are. You may just not realize that you know. Think of things like the Social Security Administration, the US Department of Health and Human Services, the New York State Department of Labor, or the New York State Division of Human Rights, and so on and so forth. There's hundreds of agencies on both the state and federal level and in states all across the country. These agencies are created by laws passed by the legislature, and they are able to create regulations, rules, policies, and guidance in order to put the laws into action and to enforce them. Regulations and rules have the full force of the law. They are part of the law, in quotes. Policies and guidance are also pretty weighty, but they are not as strong as the other forms of law. Now you might be thinking, this is a democracy. Why do these agencies get to make regulations and rules that have the force of law, and we didn't even get to elect these people? You know, who are these bozos? So I think somebody's off of mute. You know, who are these bozos, and how can we stop them from making up laws willy-nilly if we didn't even get to vote for them? Well, that is a fantastic observation, and kudos to you for bringing it up. The answer is this: when an agency goes to make or change or remove a regulation or a rule, it has to go through a formal rulemaking process that is clearly described in other parts of the law, and it includes an opportunity for the public to submit comments for or against those changes. So basically, every time they want to change regulations or rules, we, the public, have an opportunity to voice our opinion for or against what it is we want them to do. Agencies are required to take these public comments into consideration, and they cannot make up a decision that is completely contrary to what the public demands. If they did that, it would be considered arbitrary and capricious by courts, and it would not stand up. So that brings us very briefly to the last branch. I just want to point it out to you, the judicial branch. This obviously is the court system, which has judges that were appointed or elected and are tasked with interpreting and enforcing the law, making sure that our laws align with the constitutions and are being followed. And court decisions are all also part of the law. So as you can see, there are many different components to quote unquote the law, and thus many different ways to influence what the law says or does not say about our communities. So let's look at how different levels of law interact with each other, and then we're going to jump into the substance of this. So first, we have federal laws. This includes, of course, the US Constitution, federal statutes, executive orders, regulations, rules, policies, court decisions. All of this creates a floor of rights and responsibilities that every single person in this country enjoys and must follow. So no matter where you are in the country, you have to follow the federal law, and you can stand on top of the protections and the rights that are provided under federal law. States are allowed to add more rights to the federal floor if they choose to, increasing protections for people, but they are not allowed to take rights away that are guaranteed on the federal level. So here as an example, we see Texas and Ohio as states that haven't really done much to increase rights for folks who live in those states. But we see that here in New York, we have a state that's gone above and beyond in a lot of ways, increasing protections for people well above what's provided on the federal floor. Finally, many cities and counties have taken steps to pass their own laws and ordinances to provide further protections to people who live and work within the borders. New York City is a great example of this, but there are many across the state and across the country that have done so also. The big takeaway here, if you're only listening to one thing, is that even if federal rights change for the worse, state protections that go above and beyond the federal floor will remain in place. And the same goes for local rights where they're available. So states can always add to what's available at the federal floor, but they can't take away. And the extra protections we have in New York State will not change based on what happens on the federal level. Okay, so let's talk about federal rights that are pertinent to our community. So again, the assumption that we're unpacking here is that trans people do not have as many rights as, or don't have any rights as compared to LGBTQ people, and are not protected under federal and state law in the same way. So we're unpacking that. And what I want to do is take this opportunity to kind of talk about what the different rights are on the federal level to give you a sense of what's there. So we're going to try to move through this sort of fast. So thanks for hanging on to your seat with me. First thing to note is that the 1964 Civil Rights Act was a landmark piece of legislation hot in the seat of the civil rights movement in the 60s, which prohibits discrimination based on race, creed, color, religion, and sex in employment, public accommodations, voter registration, and public facilities. So this was the first law of its kind to recognize the inequities faced by folks of color and also people based on religion and based on sex in these different areas of life. So that was sort of the cornerstone for all these other laws that we see here. We're going to go into a little more detail on these other ones. Title VII is the 1964 Civil Rights Act, is the law that prohibits employment discrimination based on race, color, religion, sex, and national origin. So this is our employment protection. The statute itself prohibits sex discrimination by employers with 15 or more employees. So if you work for a company that has fewer than 15 employees, the federal law is not going to apply to your situation. But for a lot of people, it will apply. Importantly, since 1989, courts and the Equal Employment Opportunity Commission have interpreted sex very broadly as including sex stereotyping. And this came about from a case involving a cisgender woman who was up for promotion at her firm to partner, and who was entirely qualified for the position, but was ultimately passed up for the position because she declined to make some changes to her gender presentation that were requested by the partners. Specifically, they wanted her to dress more femininely, wear makeup, grow out her hair, wear more jewelry, just be more feminine. And if she did that, maybe she could make partner. But of course she didn't do that, because that's not who she was. And it went to the Supreme Court of the United States, and there the court decided that the company had illegally imposed sex stereotyping on her in a way that violated Title VII because she didn't live up to what these preconceived ideas of femininity were. That was sex discrimination under the law. Now, since that 1989 case, we've seen a whole slew of cases across the country that have taken that definition of sex and found that trans and gender nonconforming people generally are covered under Title VII. So there are a lot of cases across the country that have recognized our protections under federal law, and that doesn't just go away. Also, only very recently, there have been a handful of cases that include or interpret sex as including sexual orientation as well, with the idea that sex stereotyping also involves stereotyping people as straight or heterosexual, and if people are non-heterosexual and are discriminated against, then that is also a form of sex discrimination. Very recently, the Second Circuit, which is the federal circuit that we have here in New York, we're part of in New York, issued a decision that reinforced that idea as well. So trans people are very clearly under case law protected under Title VII, and folks based on sexual orientation are just kind of coming around to the party. All right, let's talk about Title IX. Title IX is the law that extends protection to any education program or activity receiving federal financial assistance. So that is every public school for sure, many charter schools, and even a lot of private schools receive some sort of federal financial assistance, even if it's help with transportation or borrowing public school teachers sometimes to fill gaps, or getting like a subsidized lunch program or scholarships for students to attend those schools, so on and so forth. Title IX covers K through 12 as well as secondary schools, so colleges and universities that receive public assistance too, or federal funds as well. So it covers a lot of folks. So let's talk about this one, because this is the one that's gotten a lot of confusing changes in recent years. So first thing you should know is that there are many good federal court decisions across the country that have identified trans and gender nonconforming students as protected under Title IX. These exist across the country, and they've been around for quite some time. In 2015, the Department of Education on the federal level issued a very trans-positive guidance. If you'll remember, a guidance is, has the weight of law, but it's not as strong as something like a regulation or a rule. And the guidance made it really clear to schools that receive federal funding what they needed to do to respect and support their trans and gender nonconforming students. It was a great guidance. We loved it a lot, and it was very helpful for a lot of people. Around the same time, there was a case involving a student from Virginia whose name is Gavin Grimm. In that case, Gavin came out to a school as a boy and said, "Hey, I'm a boy. I'd like to use the boys' bathroom and the boys' locker room." And the school said, "Yeah, that's fine. We don't mind. We support you." And then a bunch of parents of cis kids got very upset and went to the school board and demanded that they reverse the school's policy. And the school board agreed to do that because they were afraid of the public pressure. And Gavin sued. And during the course of Gavin's suit, he leaned heavily, and his attorneys leaned heavily on the guidance that was issued in 2015 as pointing to legal authority for what the school had done. The case was on its way to the Supreme Court and was accepted to be heard by the Supreme Court. And the only issue that the Supreme Court was going to look at was whether or not the Department of Education had the authority to interpret sex as including trans kids via this guidance, right? So we were all very excited about it. It seemed like a very promising piece of litigation that could clarify this once and for all. And then, of course, we had the election in November of 2016. Shortly thereafter, the new Secretary of the Department of Education rescinded the guidance, saying that it was no longer the department's interpretation of sex that they wanted to have out there. And because the guidance was no longer an issue, Gavin's case was no longer going to be heard in the Supreme Court, and they kicked it back down to the lower courts. So since then, Gavin has graduated and has moved on with his life. That X does not mean that he is gone. He's just no longer in this particular picture. So what does that leave us with? Well, it leaves us with some really good court decisions and a pretty negative administration. But wait, that administration's not going to be around forever either. So at the end of the day, we have a really clear statute that says you can't be discriminated in schools based on sex. And we have a lot of good court decisions across the country saying that trans kids are protected under that statute. And the rest of this is just a lot of hubbub, really. So we'll talk a little bit more about this in a moment, but I just wanted to clarify that we're actually not at such a loss as people think under Title IX as well. Okay, I'm going to breeze through these very briefly to save time. Under the Affordable Care Act, which is the Obamacare, we have a non-discrimination provision that protects people based on sex. In 2015, again, that magical summer, when lots of good things happened under the Obama administration, the Department of Health and Human Services issued a rule that interpreted sex as definitely including trans people, but actually did not make the claim about sexual orientation being covered, interestingly enough. So trans people were definitely covered under the non-discrimination provision. Right after the election in December of 2016, there was a nationwide injunction placed on that rule by a federal district court in Texas. So thanks, Texas. Which doesn't mean that trans people don't have rights. It just means that the Department of Health and Human Services can't enforce that rule anymore. So if a trans person were to file a complaint with the Department of Health and Human Services that they were discriminated against using this rule, the complaint would still be investigated, but HHS would not be allowed to pursue litigation for them on their behalf. But a trans person can absolutely still file a complaint and can also absolutely still sue under this non-discrimination provision in federal court. So we definitely still do have rights under federal health law, despite what the media would have you believe. Okay, moving very briefly to housing. We have both the Fair Housing Act and also the Equal Access Rule that was created by the Housing and Urban Development Department on the federal level. Under both of these, trans folks are covered, as well as folks based on sexual orientation. There is concern that under the current leadership of Dr. Ben Carson, that we may not have these rules for long, but there will be opportunities to submit public comment in the event that they ever become up for review and are jeopardized. So I hope you will keep your eyes open for that with regard to the Equal Access Rule. But the Fair Housing Act is really clear on who it covers and that we are covered under the law. And then finally, I just want to bring your attention to the Americans with Disabilities Act, because we're going to talk in a moment about the parallel protections on the state. So I just want you to know what you have on the federal and state level. So the Americans with Disabilities Act protects people who have physical or mental impairments that substantially limit one or more of their major life activities. When this happens, employers, landlords, and others are required to provide reasonable accommodations for recognized disabilities. So the Americans with Disabilities Act originally excluded gender identity disorder, which for most of you probably know is the old disorder, that old diagnosis that was used to diagnose trans people so that they could access treatment in the gatekeeping system that we use. But we no longer have gender identity disorder. That's actually not what we use anymore. Nowadays, with the new DSM-5, we use gender dysphoria, which is a different diagnosis. It's a different condition. Instead of saying there's something wrong with you for being trans, it now says that there's not anything particularly wrong with you for that, but it recognizes the distress that might happen in your life, the anxiety, the stress, suicidal ideation, and so on, as a result of being a trans person living in a world that doesn't like trans people. So there are a couple of courts who are considering whether gender dysphoria is something that would be a covered disability under the Americans with Disabilities Act. And it's actually looking kind of promising. So at the moment, it's a little bit questionable whether we are, but it's headed in the direction that we could be. And incidentally enough, the Trump Department of Justice issued a memo of support for this in one of the cases, which people were really surprised about, but then very shortly also tried to ban trans people from the military, saying that it was, a disability and there's something wrong with people and that's why they shouldn't serve. So sort of a double-edged sword situation there, but it is something to keep in mind. Okay, so I want to take a really brief moment and talk about the media elephant in the room. All of these things that we've talked about so far have been in the news in some way or another over the past couple of years in ways that have scared the crap out of people. and have really caused a lot of community-wide panic and also confusion about what our rights actually are. And if you just went by the headlines that you see, you might believe that trans people have no protections whatsoever under federal law, but it's simply not true. So let's take a really brief moment and look at some of those headlines. So this is one that came out, I think, late last year or earlier this year. I can't remember, I'm sorry. But the Trump rescinds rules on bathrooms for transgender students. So this is false. No rules on bathrooms were rescinded. There are no rules on bathrooms. Remember, rules and regulations have to go through a formal rulemaking process that involves public comment, and that has never happened. Like I explained just a few moments ago, the guidance that was previously published by the Department of Education was rescinded. And the head of the department, Betsy DeVos, has also announced that her Office for Civil Rights will no longer investigate trans bathroom cases. But that doesn't mean much of anything. No rules and regulations have been created or changed or taken away. The trans students still have rights under Title IX that can be pursued in court if need be. So what this means is that if you have a student who is not able to use the restroom that's appropriate to them at their school, and they were to file a complaint with the Department of Education's Office for Civil Rights, what it means is that that office is going to decline to investigate the case and give you something called a right to sue letter, or just tell you go on to federal court and send you along your merry way. But you have every right to go to federal court at that point. You can skip the complaint altogether and just file in federal court. You do still have rights under federal court. Her office is just not going to bother investigating these claims anymore, which is her prerogative, and that changes with every administration, but it does not mean that we don't have the right to do so. Okay, the next one is federal prison rollback, prisons rollback rules protecting trans people. This is inaccurate. What really happened is that the US Federal Bureau of Prisons rewrote portions of the Transgender Offender Manual to remove some of the language that had previously acknowledged a person's gender identity and attempted to institutionalize the practice of housing trans people in facilities appropriate to their gender identity. Now the language focuses on sex and allows housing assignment to be on a case-by-case basis, which is not great, right? But the manual still exists, and trans people still have access to medical treatment and still have rights under the US Constitution against cruel and unusual punishment. The rules, quote unquote, rules protecting trans people are still in place. They're modified, they're not as great, but they're not gone. So to say that they're rolled back and to call it rules is also inaccurate. And then finally, the one that we're all very familiar with because it just happened on Sunday, is this headline: transgender could be defined out of existence under Trump administration. Well, that sounds like exceedingly ominous, right? Trump is going to erase all trans people. Okay, so this is also false. Here's the truth. During the Obama administration, federal agencies created many new regulations, policies, and guidance, some of them we've just talked about a moment ago, that clearly spell out how trans and gender nonconforming people are protected under federal law when sex discrimination is prohibited. They did this by officially interpreting sex broadly in an all-inclusive way. The New York Times claims that it received a leaked memo written by the Department of Health and Human Services, which is the federal agency that deals with health programs, medical providers, health insurance, Obamacare, and some elements of educational institutions covered under Title IX. The memo allegedly proposes to 3 other federal agencies that they all work together to propose a narrower definition of sex when some of the Obama-era regulations come up for review in the next year or so. The idea is that if all 4 administrative agencies propose and eventually adopt the same narrow definition of sex, which they're saying would mean chromosomes or the sex on your original birth certificate, then that new narrow definition will be more likely to stand up in court. So in effect, these executive agencies are hoping to wipe out protections for trans, non-binary, and gender nonconforming people by narrowing the definition of sex in the law. And by the way, it's not really clear how this would impact intersex people if it were to happen. But more importantly, would they succeed with this? I would argue no, and here's why. An overwhelming number of court decisions in the past 2 decades support the fact that trans people are protected under federal law. A change in regulations cannot undo those decisions. There is established consensus among medical providers and scientists that supports trans people being exactly who they are and to have access to the care that we need to be ourselves. And also, very importantly, what they're proposing, that trans people don't exist, is factually not true. We exist by the millions. And there is legal precedent to support the rights and the protections that we have and the interpretation of sex as including us. And so any arbitrary and capricious attempt to make a baseless regulation that's not grounded in legal precedent or the facts can be overturned by a court. So what is this? I think that this was a fear-mongering attempt to freak people out right before the midterm election. I don't think it was an accident that it was timed the way that it was. But I also think, and this is super important, if you haven't listened to anything else, here's the takeaway for this. Don't believe every headline you read. They are meant to capture your attention, even if they have to exaggerate or lie to do it. I'm not saying that the media is false. I'm not saying journalists are bad. I'm not trying to say the media is our enemy. I'm definitely not on that line of attack. That's not what I mean. But I do think that they often misinterpret and mischaracterize what's happening in order to capture your attention. And if you only read the headlines alone, or even sometimes the content of what's in the substance of the article, you're not going to get the full truth about what's going on. So do your research, get to the bottom of things. If you're not sure and you can't seem to find a real answer, contact an attorney like me to explain it to you. That's exactly what we're here for, okay? And to that end, I just wanted to provide you with this. It's a part of my website that I update with counter information when stuff like this comes up. I have more details on this particular article and what it really means on my website. So feel free to go to that if you'd like to learn more about that article and to get updates in the future. So why don't we take an opportunity to have some brief questions before we keep going?
Thanks, Milo. I just also wanted to add that we can send a link to the website that you just showed.
Okay.
So if you didn't have a chance to capture it down, we can certainly follow up. For questions, one came in about how you talked, I know you talked a lot about federal court decisions that set precedent for gender identity and expression. Are there any New York specific court cases that did the same in terms of adding those, setting precedent for protected classes that we should have? And if so, what did they specifically protect against?
Yeah, absolutely. So the federal, just so you know, if you go to that link on my website, I actually have a link to another page by the National Center for Trans Equality that was recently put up to list all of the different federal decisions that have happened over the last couple of decades, so that you have access to those if you're curious to read what they are and see the ways that we've been protected over the years. So just an FYI about that. But as for state decisions, I can actually add that to the site as well. There have been a number of cases where state courts have interpreted the New York State human rights law specifically, as well as the New York City human rights law, as protecting trans and gender nonconforming people based on sex and based on disability. And we're going to get into that actually in just a moment. That's the next portion of the presentation. But there are a number of cases that have done that as well. And the protections that we have in place in New York stem from and are grounded in those case decisions. So we definitely have those in place here.
Second question is, what are other local municipalities outside of New York City that have existing protections for gender identity or expression?
Yeah, that's a great question. So I don't know the exhaustive list. I believe off the top of my head that, Rochester, Ithaca, and Syracuse are examples of other places where there are protections in place. I know that the Empire State Pride agenda used to keep an active list of all the different municipalities. I'm pretty sure that if you were to Google even their website, I think that they might still have that information up on their old site, or may have navigated it over to or migrated it to new sites that are maintaining that information. But there are a number of counties and cities and towns across New York State that have them. I don't know the list off the top of my head. but I'm sure you could find it online.
And then the last question is, you had mentioned that new proposals become open for a public comment period when they're up for review. How exactly do people comment on rules, regulations, or policy guidance?
Yeah, that was a great question. So there's two different places to do this. To keep an eye out on what's happening, first you should definitely text the number and the code that Trevon mentioned before. I'm sure that that's something that would be part of the action alerts for opportunities for action for people. But also, if you go to the New York State Register and also the Federal Register, those are the publications that come out on a weekly basis that list all of the things that the agencies are up to. And it's actually pretty fascinating to look and see what they're doing. They will often post things about proposed new rules or regulations, or when they're just kind of contemplating whether they even want to propose a new rule or regulation, and they'll seek public comment about what the public thinks, is it worth the time to even investigate and research whether it makes sense to do it. When regulations come up for periodic review, which typically happens every 5 years, they're checked to see if they're still necessary and valid and helpful and useful for keeping the law going. And when that happens, they'll pop up in the register as well to get public comments on whether or not people think that that rule is still helpful. And then when the comments come in, they will publish again to say, okay, here's sort of a synopsis of all the comments we got. Here's a summary of the concerns or the things in support that we heard, and here's our responses to it. So you actually get to see them respond to the kind of comments they were receiving and deciding whether or not they were going to take them into consideration or move past them and excuse them away. So it's a great way to hold agencies accountable and find out what's happening in your government. Often completely unawares to most of us, we don't really pay attention to agencies very much, but the vast majority of the rules and laws that we follow actually come from these agencies, and we don't even know about them until until after the fact, until they come into effect. So getting on the register, you can register your contact information to get alerts and updates if there are certain agencies you want to follow or certain rules that you're concerned about that you want to know if they pop up. That's a great way to do it. I will also be updating my website on the calls to action page and sending out reminders to people who join my mailing list when there are opportunities for public comment as well.
Thanks, Mela. That's it for questions.
Okay, great. And just to be really clear for those who have never done it before, it's so easy to fill out a comment, to submit a comment. You just have to give your contact information so they know, who you are. And just say, you don't even have to go into a lot of detail. You just say, I support this, or I don't support it, or I support it and here's why. It impacts me personally or some kids that I know, or I think it's our civic duty to support one another and make sure that everyone is equal under the law. Or if you really want to go into a lot of detail and send a researched comment, you're welcome to do it. But it really can only take just a couple of minutes. You could shoot them an email or submit it through their websites and call it done. And it's a great way to participate in our democracy that way. So
before we move on, I just wanted to also remind people, especially folks that just joined, if you think of a question, please use the chat function at the bottom of the screen to type it in, and we will have another opportunity at the end to take questions as well.
Awesome. All right, so we have just under 40 minutes left, so I'm going to try to push through. So we're going to talk about the state rights and laws that are available, protections that are available under state law, and then we're going to talk about some critical questions when contemplating GENDA and any of the other top priority items on our collective agenda as a movement. So let's dive into the state's laws. Again, this is unpacking the first assumption that LGBT or trans people don't have the same rights or have fewer rights than LGBTQ folks. So let's see what we've got on the state level. So in New York, we have something called the Human Rights Law, which protects against discrimination and harassment based on actual or perceived race, national origin, religion, and many other categories that I mentioned previously, but also specifically sex, sexual orientation, and disability. I'm going to break each one of these down in just a moment. In the areas of employment, which notably applies to employers with 4 or more employees. So for those of you paying attention earlier, Title VII, the federal law, applies to employers with 15 or more employees. So this covers many more smaller employers down to having 4 or more employees. And there's some exceptions to this rule. Employer size does not matter when the complaint deals with sexual harassment specifically, or is directed at an intern or a domestic worker. So in those cases, even if you are the only person in the office with one other person who is harassing you, sexually harassing you or discriminating against you as an intern or domestic worker, you are covered under the law. So human rights law covers employment. It also covers housing. Notably, the human rights law covers both private and public housing. So the federal law only covers housing that receives federal funds, so things like public housing, Section 8, shelters, things like that. The New York State human rights law covers that and private housing. So if you're looking for an apartment on Craigslist and you find this really sweet apartment, it's right in your price range, but right there on the Craigslist ad, it says, trans people need not apply. That would be something that's covered under the human rights law as well. Education. This is a sticking point that we're going to talk about it more in detail in just a moment, but notably, it only applies to private, non-religious, tax-exempt schools. Let me repeat that. Our education protections under the human rights law applies to private, non-religious, tax-exempt schools. So this is the part of the presentation where I usually ask people to guess how many students in our whole statewide population are actually covered who attend private, non-religious, tax-exempt schools. But since I can't really see you, I'll just tell you, it's about 3%. So about 3% of our students across the entire state, including New York City, are covered under the New York State human rights law. And the reason for this, very briefly, is a court decision that came from our highest state court in 2012 that narrowed the definition of education to only include these schools based on what's written in the tax code. So this is a huge gap of equity and access to justice in our human rights law, and it's something that needs a legislative fix so that all students, regardless of their protected status, all students would be protected under our human rights law. This leaves our students, especially trans and gender nonconforming students, exceedingly vulnerable in our schools, and something really that needs attention. So come back to that later. Human rights law also covers access to credit. So when you're applying for a loan, mortgage, car loan, student loan, credit card, any of that, you are protected against discrimination based on one of the enumerated statuses. And then finally, places of public accommodation. The law itself lists a ton of places that would be considered a place of public accommodation, including centers for public transportation, ice cream parlors, soda jerks, billiard clubs, things like that. But really, the chances are good that if you can get into a place without having to show a private membership, you are in a place of public accommodation. So movie theaters, grocery stores, public malls, libraries, law libraries, spas and hair salons, emergency rooms and hospitals and doctors' offices, most of them. Anywhere that life happens in public is a place of public accommodation and is protected under the law. So in 2016, the Division of Human Rights, which is the administrative agency or executive agency that enforces the human rights law in New York, issued a new regulation that explicitly protects trans people by interpreting sex as including gender identity and trans status, and disability as including gender dysphoria. So this is important. There was an entire formal rulemaking process where the Division of Human Rights said, hey, we want to make this rule. This is what we're thinking. The public had an opportunity to comment. Hopefully some of you were part of that process and sending in comments in support of this. And then based on the comments, they created a final rule and it became part of the law in New York. And we have these protections under the law. So this regulation is supported by several positive court decisions in New York. and is already that already considered trans people as being protected. So there were already cases across the state that saw trans people as protected under sex and under disability. This is important. I just want to point out that disability is here too. You know, just to harken back to the Americans with Disabilities Act, it's sort of unclear at this point if gender dysphoria is covered as a protected disability, but under New York State, it is a protected disability. And this is important because even if a person does not identify as having gender dysphoria or as having a disability, if they experience discrimination based on their actual or perceived trans status or having gender dysphoria, then they have that additional claim against the wrongdoer under New York State human rights law. So let me give you an example. If you are a trans person and you are employed and the employer refuses to use your preferred name until you legally change it or can show you've updated your birth certificate or some other outlandish thing, they consistently misgender you. They don't let you use the correct restrooms or make you use a weird restroom that's in the back of the basement that nobody can get to and there's a mop in the way, or they don't have health insurance plan that covers what you need, and so on and so forth. Those are considered reasonable, those could be considered reasonable accommodations under the New York State human rights law, and a violation of your rights based on your actual or perceived disability of gender dysphoria, in addition to discrimination based on your actual or perceived sex, which includes your gender identity and trans status. So it gives you a little bit of extra wiggle room and extra claims when you bring these to fore. So I want to take this opportunity to talk again about media misinformation, because this, we're not immune to it here in New York. In New York, when this happened, when this regulation came out, the news articles said something like this: Cuomo issues executive order to add gender identity to anti-bias rules. And New York State Governor Cuomo announces executive order protecting trans people from disability. Now, my favorite one is this one. Cuomo plans to use executive order to pass transgender discrimination bill. For those of you who have been paying attention, executive order is a way that a governor or a president can issue some unilateral, sort of time-sensitive policies and becomes law in and of itself, right? What we're talking about here is not an executive order, it is a regulation. And it went through a formal rulemaking process. The public got to be part of that process. It has more strength and more staying power than an executive order. This last one is funny because it says it uses an executive order to pass transgender discrimination bill, which is part of the legislative branch. So it's all sorts of wrong. I mean, they just got it all wrong on this one. But I just want to hammer home, you can't believe every headline you read. And if you thought that the protections we had in New York were a part of an executive order, you're not to blame for that. Every single media outlet, many of our legislators, our movement leaders, even to this day, continue to mischaracterize it as an executive order, but it is not. It is a regulation, and it has more staying power than an executive order. And that's a really important point that I just want to drive home. And I've already done that, so I'm not going to linger here too long. Okay. So what can people do? How can people use the human rights law to protect them and to get remedy for discrimination they experience? Well, they have two options. They can either file a complaint with the Division of Human Rights. There's a 1-year statute of limitations, so 1-year deadline from whenever the discrimination happened to file, or they could file a lawsuit in state court, which has a 3-year statute of limitations. People can do this today. We have these protections today. We don't have to wait for GENDA for this. You absolutely can use these today. If you were to look at the Division of Human Rights complaint form, it already includes specific information about what's in the regulation, that disability includes conditions related to gender identity, and sex includes gender, sexual stereotyping, gender identity, and trans status. And of course, sexual orientation is there because of SONDA, and it's whether actual or perceived. And that's important too, because a lot of trans people who experience discrimination based on their trans status often experience discrimination that's homophobic as well, because transphobes and homophobes often don't know the difference. in their bigotry and will use all sorts of things against a person. So all of these protections can be used right now by a person, even without GENDA. Okay, so that's the human rights law. I really wanted to drive that point home. And now I briefly want to touch on one form of protection our students have in New York State, now that we all know that only 3% of our students are protected under the human rights law. I want to make clear what other protections there are available to students in New York. So in New York, we also have the Dignity for All Students Act. This protects public K-12 students from discrimination, intimidation, taunting, harassment, and bullying on school property, a school bus, and/or school function. It includes explicitly sex, gender identity, and sexual orientation, among many other protected statuses. There is no private right of action with DASA, which means that you can't sue a school in court if the school doesn't comply with DASA, but you can file as many DASA complaints and reports to the school when things go wrong, and each one of those must be investigated by the school. So for example, if you've got a kiddo at a public school who is experiencing misgendering and bullying on a daily basis, you could literally write a DASA report and submit it to the school for every single time that that happens. And the school is required under DASA to investigate those reports. In 2015, the New York State Education Department, also called NYSED, published guidance to help schools treat trans and gender nonconforming students with respect. Now, emphasis on guidance. We remember that guidance has some legal weight, but it is not as strong as a regulation or a statute. So it is helpful, but it does have a tendency to say what schools should do as opposed to what they must do. And on that point, actually just this year, NYSED, after many years of advocacy, finally issued an emergency regulation that became effective in May, but is now permanent as of September, that does a number of things to further strengthen DASA. So the new regulation says that schools must, DASA reports can and should and must be written on behalf of trans and gender nonconforming students when any of these things happen. So when there's a denial of access to school facilities, when there's an application of a dress code that is based on a person's actual perceived gender identity or expression or sexual orientation or sex, the use of names or pronouns or pronunciation of names that's based on their actual perceived SOGI status, and any other form of harassment or bullying or discrimination. So this is a regulation. This went through a public comment period over the summer. It ended right after Pride in Rochester. I remember I had a booth and I asked everybody to write comments and send it into NYSED to be considered before the end date. So this was a regulation that went through a formal rulemaking process and is going to be in place for at least 5 years before its first round of review. So this is effective now. And of course, we also, as we touched on briefly, have local ordinances, including those in New York City, which are particularly extraordinary in their depth and breadth and strength with regard to trans and gender nonconforming people. The ones in other parts of the state are probably not as, well, definitely not as thorough and not as broad and strong. But there are other places across the state that have them as well. But New York City is really leading the charge as far as that goes. So I want to take a moment for questions briefly, and then I really want to jump into unpacking the next assumption if we can.
Thanks, Milo. We have one question,
Okay.
which is, how much faith should we have in the efficacy of the human rights law, given that folks are hearing from a number of community members that they have filed complaints but haven't heard back on the status of their complaint? So are there other ways for advocates to apply additional pressure on behalf of complainants?
That's interesting. So I don't know if you're referring to complaints filed with the New York State or New York City division. So there's the New York City Division of Human Rights that regulates the human rights law. What I can say for that, because that's where I practice a lot, I don't practice with the New York City Commission on Human Rights, which is separate. But for the New York State Division of Human Rights, I've had very good experiences with them with the regional directors are very open to these cases and are supportive to see them through. I've had positive experiences with the investigators who are assigned to the cases. They're not always the most competent as far as language goes, and sometimes they require some education themselves, which can be tricky. But I have advised, over several dozen clients on how to file pro se, which means without an attorney, which you can do for free with the Division of Human Rights. You definitely don't need an attorney, and who have had really positive experiences, at least in the Rochester office, with going through an investigation, getting a probable cause finding, which means that someone thinks it's more likely than not that discrimination happened, and even getting really favorable settlements for them, which included not only money damages in many cases, but also policy changes, mandatory training of staff, and a variety of other things. I know that there's even one where a bingo hall that discriminated against a trans woman was required to construct a gender-neutral single-sex restroom at their facility because of what happened. So I don't know. I haven't heard that. I know that each office is probably going to be a little different. I would say that if somebody is trying to do this without an attorney and is kind of coming across some issues, it's always worthwhile to reach out to an attorney just to see if you could get them to call and find out what's going on. The division only has 180 days to investigate the case, so sometimes there is a bit of a delay as things go along, but it should wrap up within about 6 months. So if it's lagging longer than that, that's definitely something to be looked into and concerned about. But I'm sorry to hear that other people have had negative experiences. The experiences I've had and the people I've talked to have been largely positive. So I'd be interested to hear if that's coming out of any particular office, and if there needs to be some advocacy around that issue. So thanks for bringing it up.
Thanks, Milo. I think for the sake of time, we'll just keep moving along.
Okay, great. So we are now at the next assumption, and I want to really try to take some time on this one. So the next assumption that we cannot give up now after fighting for so long is a really hard one to unpack. Central to it is an emotional bundle of nerves that are very sensitive to the possibility of winning or losing a long-fought battle. If we stop pushing now, we will feel like we failed. The communities we're fighting for will feel like we've given up on them again, because that's what always happens. And our opponents will be pleased that they finally beat us into submission and into giving up, right? If we keep fighting and get GENDA passed, we'll be elated. We'll feel like we finally have been seen and recognized by the law and feel vindicated against those who were naysayers, who said it couldn't be done, and those jerks who fought so hard to keep us from victory, and it'll feel so good. So we have a lot of skin in the game, and that makes it all the harder to consider doing anything other than carrying on the way we've been going. So what I'd like to do next is to ask some critical questions that will help us unpack this assumption. This is a tricky thing to do since it's such an assumption deeply embedded in emotional labor and love and for some folks, a lifetime of advocacy efforts. So I recognize that. And before we jump in, I just want to preface with this disclaimer that I am in no way suggesting that we abandon GENDA. I am not saying we throw in the towel or give up. What I am suggesting is that we, as a beautifully diverse and multitudinous community, must recognize that movement work does not occur in a vacuum, and that the conditions of the world around us are constantly changing. And in order to succeed, we must be critical and flexible to meet the present day challenges, concerns, vulnerabilities, and needs of our community. It is a fact that the world has changed immensely since GENDA first came to the floor. And I only want to pose questions that will help us see whether GENDA still meets the needs of our communities today. Okay, so that's what we're doing. Let's jump in. So the following questions might help us to unpack this assumption so we can more clearly see our motives and our purpose more clearly. So the first one is this: in 2002, we needed GENDA most of all. Have our needs changed in 2018? What are our most urgent needs now? Do our top priorities reflect the most urgent needs? Why or why not? You know, it's one thing to know what our people need most, and another thing entirely to act on those needs. Are we placing our most urgent needs on the back burner in order to advance GENDA with the idea of getting back to those other needs later? If we're doing that, how is it any different from what advocates have done to trans rights over the years generally? Are we just perpetuating the cycle of backburnering the needs of the most marginalized in our communities to advance the agenda of the most privileged? I'm not saying that we are, but these are good questions that we should be asking. Who decided GENDA was most important in 2002? And who is deciding the agenda today? Are they the same people? One way of figuring that out is to look at the key players leading the charge for GENDA and our other top agenda items then and now. You know, are they the same people, like literally, or are they reflective of the same group of people? You know, do they enjoy some of the same sort of privileges and power and authority and access to resources that the folks did in 2002? You know, and a related question then is, you know, who was missing from the table of decision making in 2002, and who is missing now? What can we do to change that? And are we ready for different voices? You know, is the group representative of the same groups of people? Are we seeing mostly white binary people, whether they are trans or cisgender, with access to the money, resources, and political capital, running the show back in 2002 and now in 2018? Who is funding this work, and what are the priorities of those funders? Who serves on the board or steering committees of the organizations leading the charge? Are trans people of color, trans immigrants, non-binary, intersex, disabled, or neuroatypical people represented at all in these spaces, let alone equally represented? And if so, are differing opinions welcome, lifted up, amplified, taken seriously, or are they drowned out, naysayed, or told to wait their turn to be given priority? In other words, are we creating spaces at the table for activated diversity? And what I mean by activated diversity is where diverse perspectives are not only welcome, but present, and welcome and present, but also intentionally included in all conversations and strategizing. If we are not centering the voices and perspectives of the most multiply marginalized among us, what good is the movement agenda that we are pushing? So I think that this is really important. Next is, you know, how is our emotional investment impacting our judgment? This gets to the heart of the matter, literally. One way to talk about this point is to use an economic framework that I like to think about in a lot of the things I do, called the sunk cost fallacy or sunk cost theory. And the theory is this, that we invest our energy, our money, time, labor, political capital today because we believe in the future value that we expect to get out of it, right? We're pouring it all in today because we think we're going to get something out of it. We also believe that we make rational decisions. And so it's reasonable to continue making investments toward that future value that we see. But we fail to take into account how our emotional biases are our decision-making to keep investing in something. So I'm going to give you what sounds like a trite example compared to this, but hopefully it'll make sense. I recently, in the past month, decided to paint my bedroom. And it was a slate gray, and I really wanted to bring a pop of color. So I went and got a color that was supposed to be this sort of poppy coral color that I was really excited about. And I started painting it, and it became very clear very quickly that it was much more Pepto-Bismol pink than coral. But I bought a lot of it, and I had the brushes going. I'd already like ruined the brushes with the paint. And I was like, maybe after a couple more coats, it'll look better. It'll deepen, it'll look a little more coral. So I kept going, and I painted the whole room, and I put like 2.5 coats on. And really all it was a very well-painted Pepto-Bismol room. And it took my entire weekend, and it was awful. It's really bad, right? And at that point, at some point along the way, I could have stopped, and I could have said, look, this is really clearly not working for me. I've already put this much time into it, but this is not the right color for me. Maybe I can take it back and exchange it for a different color and start something different. But I was, I felt like the right thing to do was to keep moving forward, and I had already put so much effort into it. Maybe just one more coat would make it better. And if I just finished the project, I shouldn't throw in the towel and quit. I should finish the project and see what happened. But what I got was a Pepto-Bismol room that needs to be repainted anyway, right? So that it's a somewhat silly but hopefully poignant example of how the sunk cost fallacy works, which is just to say that our emotional investment can cloud our judgment when working toward a goal in some way. And then finally, what other protections or aspects of community acceptance are still missing, even if GENDA passes? So much work has gone into this particular piece of it for decades, right? Countless cultural competency and cultural humility trainings, Trans 101 sessions, and panels of volunteers from local communities willing to answer any and all questions about being trans, sometimes having to disclose very personal details about their lives and getting emotionally burned out in the process because it's really hard to talk about yourself and your experience and your trauma over and over and over again, but we did it for the good of the people. And that has helped. Increased representation of trans people in mainstream media has helped immensely. We're no longer the comedic relief on Jerry Springer or the tearjerkers on Oprah Winfrey, but we are lead characters on dozens of TV shows and feature films, and sometimes even played by trans actors. Yay. But most people now personally know a trans person, or at least know what a trans person is, what that means. But there's still so much more to do. And it needs to be done in a systematic and sustainable way. So how will we continue to make our presence in the world known? How will we shift, will we shift from the friendly neighbor approach, like I'm just like anybody else living right next door, to something else? Even just since Sunday, with the New York Times article, my social media has been flooded with so much beautiful resilience in our community. I mean, people were really upset, but they were also really vigilant. They said, no, I am not, you can't erase me. We will not be erased. And it's a beautiful thing. People have felt a little more emboldened, I think, to be loud and clear about their existence and their right to exist on this earth. Is that something we're going to see more of in the future? Are we shifting to a different paradigm of claiming our space in this world? What does it look like? What's the plan? So I think all of these things are really important things to talk about. And also, in the event, somebody also asked about, well, no, actually, I'll just stay on point. We don't have much time. So that being said, if part of our connection to GENDA is out of principle, if we're continuing to push forward out of principle and out of emotional investment, there's nothing inherently wrong with that. It's perfectly normal and it's perfectly natural. But it's also important to consider GENDA within the larger context of the here and now, and think about how it fits with other pressing and urgent issues that would benefit from the same kind of time and energy and money and passion that we're pouring into GENDA, and how we as a community want to divvy up our resources to any and all possible options and opportunities. It is my sincerest hope, riding the wave of disgust and resilience that we all feel toward the current federal administration and state legislature, that we will see a sea change in the midterm elections and finally get some positive legislation like GENDA passed in New York, and maybe even some national protections from Congress. That maybe that's shooting for the stars too much, but if it's ever going to happen, this could be the time. We could just be mad enough and fed up enough and afraid enough to make it happen. But if the midterms don't result in the numbers that we need to make it happen, I think it's worthwhile that we consider whether pivoting toward another tack will bear more immediate and life-saving fruits in the short run, and consider coming back to something like GENDA when the conditions are more favorable to win. Again, not to backburner it or to throw in the towel, but to be realistic about where we are in the state of things, to also recognize the protections we do currently have that are there and that are good, and that are usable, and whether or not we could be putting our efforts towards some other means and other ends that would serve a more immediate purpose. So we don't want to miss other opportunities for meaningful change because we are so entrenched in one game plan. And I just want to leave you with some examples of what I mean by that. Some of these would be like fixing the human rights law to make sure that all students are covered under New York State, not just those elite few who attend private, nonprofit, non-religious schools, or push laws that would provide affirming employment opportunities for and by all LGBTQ folks. This could include, contracting incentives for businesses to contract with LGBTQ-owned businesses like they do for minority or women-owned businesses, or incubators or startup programs to train people to become entrepreneurs and small business owners and that sort of thing. Demand a statewide commission or task force to gather data on the efficacy of hate crime laws. I think that this is also a really important piece that needs more examination and more critical conversation in the community. Lobby for policies to safeguard trans folks in jails and prisons, especially in county jails and state prisons where the laws and protections are really not as clear, and many people experience abuse and neglect and assault in these spaces on an institutional level. Seeking a dignity after death legislation that would make sure that people have correct death certificates that correctly reflect how they identified in life, and not allow unsupportive family members to try to essentially detransition people after they die, but that they are able to be memorialized in all of their records as exactly who they were, and so much more, right? This is just the tip of the iceberg. There's a ton of really good ideas out there, and I think it's worthwhile to consider, what kind of agenda would be holistic and fruitful in the event that this year and the coming years are not conducive to get GENDA passed. So that being said, we've kind of touched on the first two assumptions, and I hope that it was a informative conversation for you all. That being said, we are of course out of time, so you'll have to stay tuned for the other two. But I think to that end, what I can promise is that there will be a further conversation and webinars that touch on these topics at much more length. Some of the things that will be talked about, so keep an eye open for those webinars, but things like the good, the bad, and ugly of hate crime laws, what they literally do, automatically setting a higher mandatory minimum sentence for crimes committed against people based on protected statuses, how enhanced criminal penalties are disproportionately applied to marginalized communities like people of color or immigrants or trans and gender nonconforming people, whether their intended purpose as a deterrent to hateful crimes actually works, but also a conversation around the realities of the prison industrial complex and how that fits into a modern queer agenda that we as a community want to promote and struggle for. So we will leave those important topics to another day. I hope that this conversation was informative and inspiring, and will inspire you to have further conversations moving forward. I did provide some quick final takeaways in case you did not hear them as I said them, if you were multitasking. And aside from that, please feel free to reach out to me directly if you have any additional questions or concerns. Trevon, any last notes?
Thanks, Milo. And I just want to thank you all again for joining and taking the time to provide your thoughtful questions. I also want to thank Milo for his robust and insightful overview. I will be following up with everyone who joined today's webinar and others who have expressed interest in receiving a recording of the presentation, just so that they can have more time to unpack it. So that will be made available as well. If you have any additional questions in the interim, please feel free to reach out to myself or Milo directly. And I look forward to talking to you all soon. Thank you.
Thank you so much.